We are now about to start the second session of this conference. This is a special session on the European Unified Patent Court, launched in June 2023, and this session will be conducted in English. The moderator for session 2 is Honorable High Court Presiding Judge Kang Jin-baek of Jeonju Branch of Gwangju High Court. And the speaker is the President Klaus GRABINSKI of the Court of Appeal of the Unified Patent Court. Please join me in welcoming them. First, President Klaus GRABINSKI is going to give us a presentation on the Unified Patent Court. And then Judge Baek and President GRABINSKI will discuss the UPC in more depth. Now I'd like to turn the floor over to President GRABINSKI. Please give him a big round of applause. Slides, please.
Thank you very much for your kind introduction. Good afternoon, everyone. It's a great pleasure being here, and I'm very grateful that I have the opportunity to present to you hopefully the main features of the Unified Patent Court, a patent court for Europe. But before getting to the court itself, it is good to have a look back. So what was the situation before the agreement, which is the legal basis for the court, entered into force? So let's turn to the state of play until 31st May 2023. There was one beauty of the European patent system that concerned the pre-grant phase of a patent. So instead of having to go to each national patent office in Europe, like the situation was before the 70s, so you wanted to have patent protection in France, you had to go to the French patent office to get a French patent, you have to go for getting protection in Germany to the German patent office for getting a German patent. On the basis of the European Patent Convention, as of 1977, when the convention came into force, the signature date was 5th October 1973, it was only one office where you could go. And filing and getting a patent from that office gave you protection in all the contracting member states. At the beginning, there were less than 38, but now it's 38 member states of the European Patent Convention. However, what you got? So once the patent has been granted, the patent gives you the effect of a national patent granted in each of the contracting member states, provided the patent has been validated and maintained in each of these states. So the downside of this was that you had to pay a lot of money for fees when you wanted to get protection in a number of contracting member states. So it can be up to 38 member states if a patent owner wants to have protection in these member states. They have to pay fees in all these member states. And on top of that, as the European patent gives protection like a national patent in each of the contracting member states, in practice, it boils down to a situation that when the patent has to be enforced because there is infringement in the member states, that you have to go state by state. So in order to enforce the German part of the European patent, in practice, it is very often necessary to litigate in Germany. When it's about the enforcement of the French part, you have to litigate before the French national courts. There are some exceptions to this, but in general, that is the practice. And when it comes to the validity of the patent, so someone is attacking the validity of the patent by filing a revocation action, again, this has to be done state by state. So when filing a revocation action with regard to the German part of the European patent, the case has to be brought before a German court, the competent court, and when it is about the French part, the action has to be filed with the French court. So, in short, to sum it up, pre-grant, there's a centralized procedure before one patent office, one-stop shop only, but after grant, when it comes to validation and maintenance of the patent, it goes state by state, and also when it comes to enforcement, it normally goes state by state. And the idea of the UPC and also of the unified patent is to improve this situation. And this is how it works, or what is the new offer since 1st of June 2023. When it concerning the patent court, since 1st of June 2023, based on the agreement of a unified patent court, which entered into force as of that date, there is a court before which the patent can be enforced with regard to the contracting member states, which are at the beginning 17 out of 27 EU member states. And at the same time, those who have a patent application and the patent has already been granted can opt for, instead of having a European patent, the bundle patent, state by state, they can opt for the 17 contracting member states of the Unified Patent Court agreement. They can opt for unitary protection. So it is only one patent and only one patent office who takes care of the maintenance of the validation and maintenance of the patent, which is the European Patent Office. So the idea of the Unified Patent Court is essentially that this is a court of the contracting member states. So the Unified Patent Court, in other words, is at the same time a French court, a German court, a Dutch court, and I could name all the 17 contracting member states that has jurisdiction with regard to European patents. So the UPC has exclusive jurisdiction where the court of a contracting member state would have jurisdiction in European patent matters if the UPC agreement had not transferred that competence to the UPC. So to give you a scenario, there is an alleged infringement that takes place in France, in Germany and in the Netherlands of a European patent. Before, you had to go, in order to enforce the patent, to the French, the German and the Dutch court. Now, it is possible to bring the case before one court only, which is the UPC. And that, of course, is the other side of the coin, that also when a competitor wants to attack the validity of the patent, the action can be filed with just one court. So also attacking the validity of the patent with the French, with the German and the Dutch part, in my example, before only one court, because this court is considered to be at the same time a French, a Dutch, and a German court, and so on. There's one exception to this. Patent owners who don't like the new system have and had the opportunity to opt the patent out. When the patent is opted out from the system, which is done by a simple declaration in front of the court, of the UPC, then for that European patent, everything applies that I've told you applied before 1st June of this year. So all patent owners who don't like the system can opt out from the system with their European patent. And have done so also already. When you look at the numbers, potentially there are about 1.5 million European patents and published European patent applications that potentially can be opted out. And out of these 1.5 million, roughly, about a third has been opted out. But there's also the possibility to opt in again unless there is a case pending before a national jurisdiction. Then it is no longer possible to withdraw from the opt-out. Now, let's have a brief look at the unitary patent. Unitary patent, as mentioned, can be in the after-grant period can be maintained with only one patent office, which is the European Patent Office. These patents, for these patents, it is only the Unified Patent Court who is the competent court with regard to, on the one side, infringement actions, and on the other side, the revocation actions. And the unitary patent confers to its proprietor protection throughout the territory of the contracting member states and reduces complexity and lower costs. When you go to the website of the European Patent Office, they did a calculation with regards to fees, and they compared the maintenance fees over a certain duration of the patent in the 4 member states where most of the patents are validated and maintained in practice during the last years. So these were Germany, France, Italy, and the Netherlands. And the maintenance fee costs for, when you compare this for a certain duration of time with the maintenance fee you have to pay for a unitary patent, the result was that it is 29% lower fees for a unitary patent, with which you have coverage of 17 contracting member states, compared to the maintenance fees for only these 4 states. Now let's have a closer look at the structure of the court. As you can see, the Unified Patent Court has a court of first instance and a court of appeal, and it also has a patent mediation arbitration center. Actually, this is not yet set up, but it is going to come very soon. So the court of first instance splits up into local division, central division, and regional divisions. So what does it mean? Local division means that there is one contracting member state hosting a local division. Regional division means that more than one contracting member states share a regional division, and there is a central division. The local infringement actions normally are brought before local divisions or regional divisions, depending on where the infringement occurred, the place where the infringement occurred. While central division essentially has jurisdiction on the revocation actions, isolated revocation actions, as well as actions for declaration of non-infringement of a patent. As you can see on the right-hand side, there is also the European Court of Justice mentioned. That is an interesting and important aspect. In the European Union, the interpretation of European law is exclusively falls into the competence of the European Court of Justice, and therefore the national courts make referrals to the European Court of Justice when a legal question of interpretation of EU law is either unclear or has not been clarified by the European Court of Justice. And the same system applies also to the Unified Patent Court, because the Unified Patent Court is nothing else, nothing different from a national court. It is just a court not only of one EU member state, but of a number of EU member states. But apart from this, the same principle, relation between the Unified Patent Court towards the CJU is the same like a national court towards the CJU. So when an issue of EU law, interpretation of issue of EU law comes up, and it is not clear and not clarified, then also the UPC has to make a referral to the CJU. But at the same time, I should mention that a large part of European patent law are not EU law. They are law under the European Patent Convention, which is not part of EU law. Here you see a map of Europe, and the dark blue states are the contracting member states where the UPC agreement has been ratified. So these are the 17 contracting member states. You see in a slightly brighter blue those states, contracting member states that, those member states that signed the agreement but not have yet ratified the agreement. And then in the very bright blue, Croatia, Poland and Spain are those EU states that have not neither signed nor ratified the agreement. If you allow me a very short remark in that regard, when you look at the European Patent Convention, it also started with a few European states and then more and more joined. That's a rather normal way how this develops. There was a minimum number of contracting member states for this new court, for the agreement, which was 13. And at the beginning, it were 17 who started this. And the system is open for all those EU member states that not have yet joined the system at all time. And I was informed from Ireland that they will have a referendum soon on whether to ratify the agreement or not. That there's an it is under their constitutional system, it is necessary for them to have a referendum before ratifying an international agreement. You also see on the map the locations of the local, central, and regional divisions. You also see the two places of the PMAC, the Center for Arbitration and Mediation, and you also see the place of the training center in Hungary. This is actually not also not realized at the moment because Hungary preferred not to ratify the system at the moment. Now, how is the composition of the panels that are going to decide in the cases? As you can see, Central Division, it is a panel of 3 judges, 2, we call them LQGs, so legally qualified judges, and 1 technically qualified judge. So the technically qualified judge, of course, is from the field of the technology of the patent. You know, patents are classified under the IPC classification system, and accordingly, the technically qualified judge of the field of the patent in litigation joins the 2 legally qualified judges. In the local and regional division, you usually have 3 legally qualified judges. Sometimes they can be, 2 of them can be from the member state hosting the local division, sometimes it's only one. And they are always joined by either one or two legally qualified judges from another contracting member states, which means that the panel is always an international panel. It is never only the judges come from one member state. And most of the time, they are also joined by a technically qualified judge from the technology of the case. At the Court of Appeal level, a panel of 5 judges is sitting on the case, and it is 3 legally qualified judges and 2 technically qualified judges from the respective field. If you ask me about the background of the technically qualified judges, partly they are technically qualified judges from the national jurisdictions. They are technically qualified judges in Sweden and in Germany in particular. But in other countries, there are no national technically qualified judges. So from these countries, they normally come from the ranks of practitioners, so patent attorneys. But they can also be retired EPO Board of Appeal members, not active Board of Appeal members, or they can also be sometimes examiners from national patent offices. There can be issues of conflict of interest when they are patent attorneys, but there is one rule in the Code of Conduct that provides that you cannot, when you are a technically qualified judge in the UPC, you cannot represent the case before the UPC. You can represent the case before a national court, before a national office, or before the EPO, but not before the UPCA. So you cannot be on Monday a technically qualified judge and on Tuesday represent the case before the UPCA. That is not allowed under the Code of Conduct. Well, as to languages, you all know in Europe we speak a lot of languages. So what is the language of proceeding before the UPC? In the central division, it's always the language of the patent. And the European Patent Office has 3 official languages, and the patent applicant can use one of these. And that language is always the language of proceeding before the central division. Before the local and regional division, it is either the official language of the contracting member state hosting the local division or sharing the regional division, or when the contracting member states designate a second or third language, it can be one of the official EPO languages. So in practice, there were respective designations from all contracting member states hosting a local division. It is the official language and English. So before the local divisions in Germany, for example, it's German and English. Before the Dutch, it is Dutch and English, and so on. The one exception is the regional division. There's only one regional division, which is located in Stockholm. It's a regional division of Sweden and the 3 Baltic states, and they all decided it is only English. It is not Swedish, it is not one of the Baltic languages, it is only English before the regional division. And there's another example maybe worth mentioning, that's in Brussels, as they have 3 official languages. In Belgium is the 3 official languages and plus English. So you even have 4 languages at your choice as a claimant. There is one provision that's maybe also interesting. Of course, when the parties agree and the court agrees, they can agree on the language of the patent instead of the official language of the member state hosting the local division. But even at the request of one party and after having heard the other parties, the President of the Court of First Instance may decide on the language in which the patent was granted instead of the official language of the state hosting the local division. And this has been played already in one case. So in this case, I think it was in The Hague. It was originally Dutch, and then the president decided it should be English. Court of Appeal normally follows the language of the Court of First Instance. Well, the court is up and running since 1st of June of this year. And since then, 90 cases have been filed with the Court of First Instance as of 24th of October 2023. And here you see the kinds of cases that have been filed: 47 actions for infringement, 6 counterclaims for revocation, 23 actions for revocation, and of course also preliminary measures, preserving evidence, and requests for inspections. Now, a very brief look at the proceedings. Important is that it is a front-loading system, which means already in the written procedure, all facts and all evidence has to be submitted to the court. So when you come later, that may be a problem. You may be asked, why do you come later? And it might be that the fact or the evidence is not allowed. So the idea, of course, is to have it all up front, so that at the end the oral procedure can be done no longer than 1 day. Then there's an interim procedure which mainly has as purpose the preparation of the oral hearing, so summoning witnesses or experts if necessary, setting the date of the oral hearing, but also exploring possibilities whether the case can be settled. And then of the oral procedure, which is, I guess, quite similar to the oral procedures as you know it in the courts here in Korea. It can start by a preliminary introduction to the case by the judges. So the judges, the judges are supposed to have read everything that has been submitted, and based on this and maybe a deliberation a day before the oral hearing, they may give an introduction to the case, make transparent the preliminary view on the case, and invite the parties to focus on those issues that, from the perspective of the panel, are decisive to decide the case, are relevant to decide the case. So that right from the beginning, the discussion, the pleadings are focused on the issues that have been identified by the panel to be the decisive issues of the case. Then this, of course, is followed by pleadings of the parties. Time limits may be set in advance. This is, if I may say so, a heritage from the UK. The UK took a very active part in the drafting of the rules of procedure. And this is unknown, at least from a German perspective, but everyone was convinced that this may also be a good idea to keep the oral hearing short, but at the same time focus on the issues that are decisive for deciding the case. Then, of course, hearing of witnesses and experts, judges and parties may put questions, and then endeavor to complete the oral hearing in 1 day, which does not mean, of course, when it's a very complex case and the panel feels that they need more pleadings and need more facts in order to decide the case, then of course it can also take 2 days. Or they adjourn and they hear witnesses and come back and have a final hearing. That's always possible, but in principle, when we talk about an average case, it should be completed, the oral hearing, in 1 day. Video conferencing is available, but the principle is that the judges are present in the courtroom. Representatives and parties may be allowed to attend the oral hearing by video conference. And complete video hearing that is completely run by video conferencing is possible only in an exceptional situation like a pandemic, or with consent of everyone concerned, of course. Then there's public access to the electronic register. Decisions and orders are published. Written pleadings and evidence are available upon the reasoned request by decision of the judge rapporteur after consulting the parties. And of course, a party may request that certain information be kept confidential. Protection of confidential information is possible. Confidentiality clauses are available if there's a need. That may, of course, in particular arise in SEP cases. But it cannot be completely kept away from the other party. There's always one national party from each party that has access to also this confidential information and the representatives. Pre-trial procedure, well, no pre-trial discovery US style available. It is more focused. Order to preserve evidence or inspections are available. And we already had cases, as I mentioned. And provision and protective measures are also available. Experts, party experts or appointed experts are available. I don't expect many court-appointed experts, as there are already technically qualified judges on the panel. A permanent injunction, yes, it is of course available, and there is no eBay test US style available. That's case law in the US, but not applicable in Europe. But also injunctive relief has to be proportionate if argued. So that can also can become an issue. Award of damages, you know the three ways of calculation of damages: lost profits, return of infringers' profits, royalties, but no punitive damages. And this is maybe the last slide I would like to cover. Well, the judges come from different jurisdictions, from France, from the Netherlands, from Germany, Italy, and so on. And they all have their particular format of decisions. For example, in Germany, you have the operative part of the decision, the order, in front of the reasoning. So you first have the operative part, then you have the facts, and then you have the reasoning. While in France, it's different. They have the facts, they have the reasoning, and then the operative part. So in order to have a unified patent court, so have the same approach, have the same format, the court has had to develop some kind of uniform format for it. And there are templates and also guidances available on the UPC website. And this is an invitation to the judges, but not only to the judges, also to the representatives, to use a particular format that's not about content, but is more about format. And so the decision was that the operative part, according to that template, has to be at the end, always, of the decision, not to continue following the German tradition to have it at the beginning. So it's a bit like in traffic. You have to decide whether you have that you drive on the left side or on the right side. So but this kind of decision had to be taken in order to have it really a uniform court, also with a uniform format. But it's also getting a bit more important than rather have it at the front or at the end of the decision, the operative part. For example, how to draft an injunction. There are some in some countries you do it by repeating the wording of the patent claim. In some countries you simply say, well, stop or making use of the patent, and then only the number follows. But also in this regard, there are guidances and the purpose of these guidances is to invite representatives to draft their requests according to the guidances, but also invite judges to draft their operative part and decisions according to the guidances. And one more slide. Here you see a few locations where you have local and regional divisions. In Europe, I ask the audience, do you know where the places are? But here in Korea, I just lead you through the pictures. So on the first line, first picture, this is the regional division in Stockholm. The next one is the local division in Vienna. The next one is the local division in Düsseldorf. The lower line, you may have a feeling for this. This is a view on Ile de la Cité in Paris, but it is not the place where the local division is located, but is the view from the local division on the Ile de la Cité. But they have courtrooms there. And the next one is the Court of Appeal in Luxembourg, former Parliament building of the EU. And the final one is the local division in Milano. Thank you very much for your attention.
Thank you very much for the wonderful presentation. Big applause, please, again. Now I'd like to hand over the mic to our moderator, Honorable Judge Kang Jin-baek. Please welcome him with a big applause.
Please turn on my mic. Hello? Okay. So you're in Luxembourg, right?
That's true, that's true, yes.
So the whole building is an appeal court building, or you're
No, it's just a floor of this at the moment, and we get another one in the near future.
So how many cases you have now?
At the Court of Appeal level, we have currently 2 appeals, well, one pending and one already decided. That is something unknown from a German perspective, but available under the rules of procedure of the UPC, that we also have procedural appeals. And the first decision was on a procedural appeal issued by we have 2 panels at the Court of Appeal, and this decided by the panel, the other panel, where we have a colleague of mine here.
So in Korean perspective, it's amazing. After 4 months, you have already appeal case. So it's very fast court, in my view. And thank you very much for the comprehensive presentation. It's very informative, and we learned a lot from your presentation. And I know this is really a precious, unique opportunity for us. We saw this morning session that each country has their different systems, and even for us, experts like us, it's very complicated and hard to understand. So this kind of unified court is ideal, like dreams come true, really. And we have here today the Chief Justice of that court. How lucky we are. So, but I guess this is the most popular time during your tenure, right?
Sorry to interrupt, but it's a mic again, so can you give us a few times, please?
Yeah. So, it's
Thank
better?
you so much. Yes, please continue.
So, I know your audience have many questions, and unfortunately we have time until 3, so it means 10, 24, around 40 minutes, right? Yeah, so let me ask Dr. Grabinski some very basic general questions, and then the last 20 minutes will go to the floor, and I'll take question as a moderator. So I already feel it's running out of time, so I'd like to begin with a very basic question. So I told you this is very ideal and very promising, but how is the reality? Isn't there any concern this system add more complexity on the existing system? If not, what is your measure to make this patent application or revocation system more efficient, simple, or faster? So please.
Actually, it is a kind of offer at the moment. You can, it makes possible if you want to litigate in more than one contracting member state, that you can do it before one court. That is the offer. but in the transitional period for 7 years, every proprietor of a patent can decide which way he or she wants to go. So you can, on the one hand, you can decide you don't like the system at all, then you opt out. You decide, okay, I like the system, I want to make use of it, but I also have the possibility at the same time to bring cases still to the national courts. That is another offer, then you stay in the system. Or you like the unitary patent, you have a patent granted, and then you have 1 month's time to decide, okay, I don't want to have the conventional bundle patent, I want to have a unitary patent because, well, I pay the price for 3 to 4 and get protection in 17 contracting member states, which may be an advantage for your economic concept. And then you may opt for unitary protection. And then, of course, when the patent has to be enforced, then it is only the Unified Patent Court where you can do this. At the same time, you have to take into consideration that the judges that have been appointed for the Unified Patent Court are, at least most of them, are the judges litigators already know from the national jurisdictions. So they are not new judges, but they are experienced judges. And some of them became full-time judges in the UPC, and others became part-time judges, so meaning they have a hat as a UPC judge, at the same time have a hat as a national judge. And you may ask, why is this that you have this part-time system? Well, the idea is, at the beginning, nobody knew how many cases will be brought to the court. But at the same time, judges have to be paid for. And so the idea was, well, we wait and see. When there are more cases, the working time of the judges in the UPC will be increased. And we are currently already at that, in the situation where we think, and we already did so, and we increase the working time of the judges because it is not sufficient working time at the moment. Yeah.
Okay, so I understand you're ready to make process more efficient and try to give more options to the patent applicants, like opt out, and even after opt out, you can opt in again, right? So
yes, under one condition, when you opt out, and then the patent is litigated. Either you base an infringement action on the patent, or the patent is against the patent, a revocation action is filed before a national court, then you can no longer opt in.
Okay. In terms of European patent, you have option whether you have the patent with unitary effect or without. But how about national patent? Is it wise to keep national patent at the same time with European unitary patent?
Well, with regard, it is always possible to file for a national patent, for example, for a German patent, and at the same time for a conventional European patent. But when and normally it was first the national patent that was granted. So, for example, the German patent, and then later also the European patent was granted. And then, of course, you have the overlap between the German patent and the European patent. And in that regard, at least in Germany, there was a prohibition of double protection, which means that then the German patent has no longer any effect. It only helped you to have it earlier than the European patent. Okay. But after the European patent has been granted, and of course only when it really overlapped, then it was only the European patent that was still existent. Now with the new patent system, it is different. You can even have double protection. So you can always have the national patent, but you can even have a double protection. The only thing which is not possible is to litigate at the same time. For example, for patent infringement based on the German patent before a German court, and based on the unitary patent before the UPC. That is not possible.
Okay, so it means it's a more stronger protection
Yes.
could be given by UPC. So to the contrary, if you, in terms of revocation, invalidation, if your unitary patent was held invalid, it means it was killed by one shot. So it's patent holders' perspective, it's very risky choice could be. And also I found that your EPO's opposition process to patent still exists. It means that you have two tracks. You can file opposition to EPO, and at the same time you initiate the revocation suit in UPC. So what is the relation between two processes?
That's true, but this is has always been true. So also in the old system, it is possible that you file in parallel an opposition, and then in most member states of the European Patent Office, so of the European Patent Convention, you can in parallel also file a revocation action. There's one exception: you cannot do this in Germany. So you can only file a revocation action in Germany when either no opposition has been filed or opposition has come to an end. Before you cannot do this. So the situation now with the UPC is that indeed you can file opposition and in parallel also a revocation action. With regard to the first argument you mentioned, that you now can file a revocation action before the UPC and then in one action have the patent invalidated, while before you had to go to the national courts for your revocation case. That is formally true. However, when you look at the practice also in the past years, when the revocation action was successful in one or two of the main jurisdictions, then what is the patent still worth? It is no longer respected in the market anymore. I very often hear the example saying, "Okay, don't put all your eggs in the basket."
Right.
And I know this from financial situation. You mean then you have different asset classes, and when you have different asset classes, so the one asset class goes the wrong way, then you still have the two. But this means that the asset classes are independent from each other. While when we talk about one patent, and as said, it is has been revoked in two of the major jurisdictions, then okay, then it is it is not respected that much any longer. So we are not talking about different assets classes.
Okay, follow-up question. So if EPO declares that this patent is invalid, later in the revocation process, UPC can say, no, this is valid. This is
no. When the EPO declares a patent invalid, then it is gone.
Gone.
So the only interesting situation is when the patent is revoked in part before the EPO and also in part before the UPC. So what remains, and it is a bit like overlapping. You see, okay, this part remained before the in opposition, this part remained before the UPC, and then where it overlaps, that's the remaining part at the end of the day.
Yeah. So, to my knowledge, the opposition process has time limit, right? It should be filed within
9 months.
9 months, right? So usually opposition process start first if you attack a patent.
Not necessarily. Within you can also file a revocation within the 9 months, even earlier. That's not necessarily the case. But then you have it in many countries that you can file, not in Germany as mentioned, but that you can file the revocation and opposition, and then the question in the revocation case comes up, well, how to deal with the parallel opposition proceeding. And the practice in many countries is, well, to look, well, how long will it take for the in opposition proceeding to decide the case. If it takes long, then they go ahead and decide in the national jurisdiction and don't wait for the opposition proceeding.
That would be the same case in UPC?
Probably, yes, yeah.
Okay.
More or less, yeah.
Right. Only 10 minutes left, and I have only 2 questions. But this is the most interesting part in relation to what we discussed this morning. Many speakers mentioned the technical advisors, experts, but in UPC, we noticed there's a technically qualified judges.
Right.
You explained who they are and where they come from, but my question is whether they have same vote or same quality of voice on the legal matters in the deliberation, for example.
Well, you don't find anything on this in the agreement. I think the agreement is based on the assumption that, of course, every judge has the same vote. But I would not expect that the technically qualified judges take care only about the technical issues and the legally only take care about the legal issues. But my expectation will be that they are all they are responsible in both regards, technical and legally, and so they should be involved equally in both regards. So the legally qualified judges have to understand also about the technology and at the end be in the position to decide the case in that respect, as the technically qualified judges have also to understand the legal implications of the case and also be able to decide on this.
Okay, so I heard that patent attorneys can represent the parties in UPC. So they can represent parties alone without joint representation with lawyers. Is it true?
That's true. If they have a further qualification, essentially, when one requirement to represent the case as a patent attorney before the UPC, then probably the decisive requirement is that you are allowed to represent the case before the EPO. So, and if that requirement is given, then you can represent the case. For example, interestingly enough, patent attorneys from the UK, even though, as you know, UK is not part of the UPC, patent attorneys who are qualified to represent the case in opposition proceedings before the EPO, and they have the extra qualification, can also represent the case before the UPC, while, for example, UK lawyers cannot represent a case before the UPC when they are only admitted to in the UK, because lawyers have to admit it in one contracting member state of the UPC.
So it's interesting fact. To represent parties as a patent attorney, he or she needs some certificate, like legal education or some extra training, or he or she just can file a permission, then get a license? Well,
they need a certain qualification. That's laid down in the agreement, and you can have respective training, and then you are qualified.
But I guess that leads to the technically qualified judges.
Yeah.
The whole system is even the technical expert can learn some legal skills during the process.
I was speaking about the representation. So the technically qualified judges is a different thing. They don't need this qualification. The qualification they need is they have to be national from one of the contracting member states, and they have to have a graduation from a technical university, these kind of requirements. And then the system how to become a judge in the UPC it's clear. Well, this is for the technically qualified judges. For the legally qualified judges, you have to be eligible to become a judge in one of the contracting member states, and then you can apply to become a judge. And then there is a advisory committee, and they published courts, and then they did interviews with the judges. Of course, there's also written application, and then they put you on a list or they don't. And based on this list, then you can be appointed to be a judge by the administrative committee.
Okay, it's very interesting part of UPC in my view. And we have four minutes. As a judge, I find it very interesting when you talk about the operative part of the judgment. I have experience working as an United Nations international judge, and my colleague was French, and the court, the decision, the operative part comes last. But in Korea, the operative part comes first. So sometimes the decision, the judgment is like 500 pages. You don't know until you read the last page. What is the conclusion of this case? So it's very interesting. So in that sense, as a chief judge, how do you conceive to harmonize the multicultural judges and how make the process efficient? Sometimes you can use multiple languages in a session. So is there any idea or vision on that?
I think there are different ways to deal with this. As mentioned, the panels are, as provided for in the agreement, will be multinational all the time. Sometimes there may be two coming from the same countries. Sometimes all are coming from different countries, at least the legally qualified judges. And well, they influence each other. They learn from each other. And what I during a training told them, well, please stop thinking, okay, we do this in my home country like this, but better look at what the agreement tells you, what the rules of procedure of the UPC tell you, and try to follow that way. But at the same time, of course, there is already case law in the contracting member states existing, and very often it is already aligned. There is not much different because they are all based on the same provisions. That the European Patent Convention is in place almost 50 years now. Also, the definition of what is a direct infringement or indirect infringement is, even though it is part of the national law, has been harmonized already quite some years ago. So the court can build on these aligned provisions and interpretations. But at the same time, particularly with regard to procedural law, they now have to become familiar with the rules and develop their own style. And if it goes differently in different local divisions, I don't know, the one in the north is different from the one in the south, then at the end is the role of the Court of Appeal to find the right way, and then the normal idea would that they then follow the harmonized approach taken by the Court of Appeal.
So I saw in your presentation there's no eBay, no discovery, like you have your sui generis procedural rules and of course agreement. So you can confidently say this system is harmonized all the system of the world, including US. So in the sense, so judges think the educational background are very different, but this is not possible. But if judges in a country has got education from USA and insist on US system, so you can say our UPC stick to the rules. This is a very harmonized, neutral system. So
at least I would consider this to be the common ground for developing the case law, and yes, I think that's the way forward. Yeah.
All right. So it's already run out of time. So I have many questions to ask, but I know this is not the session dedicated to me. So this is session for the floor for more engaging and more interactive discussion. So now I'd like to open the floor for questions. Okay, the microphones are ready?
Yes.
Okay,
They're ready.
please raise your hand if you have questions. Okay. State your name and affiliation before asking a question, please.
Yeah, thank you very much. Thank you very much, President GRABINSKI, for your great presentation. It was so informative and it helped me a lot to understand how the Unified Patent Court of Europe was created and its features and benefits as well. My name is Joe Kwok. I'm a partner of Intellectual Property Practice Group of Lee & Co. based in Seoul. And I also serve as Secretary General of KIPLA, Korean Intellectual Property Lawyer Association. I have a couple of questions regarding the impact of the UPC from a big picture perspective. So the first one is, could the introduction of the UPC institutionally make the European IP market more attractive than the US IP market in the future or in the near future? I would appreciate your views on this. And the second one is, there are a lot of countries in the EU, and each country may have different advantage or benefit in perspective of adopting the UPC. So I would like to know if you have any experience of analysis on that. And from the same perspective, I also wondered how the advantage and disadvantage of large companies and small companies, relatively middle-sized and small companies, and as well as European companies and foreign companies. So thank you very much.
So you have 3 questions already.
Yeah. Yes, well, when I look at the US, but we can also speak of other big markets, you normally have the principle, okay, there's a big market, and you have one patent for the market, and you have protection all over, and when you want to enforce the patent, you go to one court, and you enforce it in the whole market. The problem in Europe before 1st June has been, well, there's one single market, but there are many courts in the different national jurisdictions, and when you want to enforce the patent, you have to go country by country. Sometimes, of course, it was good enough to get an injunction in one of the big jurisdictions because of the kind of product. But some products, if you have an injunction in one jurisdiction, they continue to use the patent or infringe the patent in the other jurisdictions. And now with the UPC, Europe is well, leveling up, getting to the same level like other big markets, but offering to patent owners the possibility to enforce their patent before one court. And well, we already discussed, and then the argument is very often raised that, okay, the downside is it can be attacked centrally, but well, in the US market or in other big markets, you also attack a patent centrally, so that's not a different. So it's it goes both ways. So when you want to have the advantage of enforcing a patent before one court, of course you can also attack before one court. That's a normal thing. So I think that's I hope a fair comparison to the US situation. And with regards to small and middle-sized companies, there were also raised concerns in Europe about whether this is going to be a court for the big companies, for the rich companies, for the deep pockets. I would not think so, because before 1st of June, at least in Germany, I've seen a lot of litigation, small and middle-sized companies before the German courts. And they had to pay, when you bring a litigation before a German court, you have to pay a quite significant court fee. And now with the UPC, I did at another occasion a comparison with regard to fees. Also court fees, when you litigate the patent, it is less. When you take the same value of litigation, that's the basis for the calculation of court fees in Germany, and it is also the basis before the UPC, and you see what fees you have to pay, you pay less when you have the same value of litigation. So in that regard, I don't see a disadvantage from the perspective of a small and middle-sized companies. There's another aspect to be mentioned, that is the reimbursement of representation costs when you win the case. Because in Europe, that is, I think, a difference from the US system. The winning party can get reimbursed for the costs they have with the litigation, so appropriate costs for representing in the litigation. So this cost shift principle is applicable in Europe, and and there, when you look what fees can be reimbursed, then they are quite high also compared to the German numbers. But these numbers are ceilings, so it does not necessarily mean that you have to get the full numbers that you can see as a reimbursement. So also in that regard, I would suggest to wait and see how this will develop. And what was the other question? Sorry, I forgot one, I guess.
I forget too, please. What was it, the second question? You answered the last question, right?
Yes, yeah.
What is the second question exactly?
Yeah, actually, my second question is, is there any different interest or benefit in adopting UPC between the large company and small company? And the second one, and the third one is European and foreign companies. Is there any difference between them?
No, there's no difference between European and foreign companies, no.
Thank you for your explanation.
Okay.
Thank you.
Excellent. Next question, please raise your hand. Okay, okay, to the right corner, please, go ahead.
Okay, thank you for your outstanding presentation. And my name is Sang-Hyun Lee, Korean attorney of Beck, Kim & Lee, LLC. This might be a little bit minor or specific question. And it is very interesting for me that the current UPC system now recognizes the possibility of conflict with the EPO proceedings. So, do you have any legal ground that the UPC can stay its own proceedings due to the EPO proceedings?
Well, the UPC can stay.
Yeah.
And as mentioned, one important aspect, whether to stay or not to stay, will be whether a decision in opposition proceedings or appeal in opposition proceeding can be expected very soon, or whether it takes some time. The UPC panel also has the possibility to ask for expedited proceedings in opposition proceedings. So that may be another way to deal with the situation. Of course, that should be done at an early stage of proceedings. So when you, for example, expect a revocation action to take 1 year, then it would be make sense if such a request from the UPC to the EPO, to the boards of appeal, or to the opposition division is issued at early stage. And EPO is very willing to expedite cases if such a request comes from the UPC.
Okay, next question. Okay, go ahead, please.
My name is S.W. Han, the attorney from Kim and Chang law firm. And very quick question for the permanent injunction requirement. So your slide 20, page 20 has the explanation of no eBay test, US style, but the injunction has to be proportionate. So I understand that in the past, German court, like the Düsseldorf Munen, has a tendency to issue the injunction without considering the eBay test, as you explained. But under the UPC system, do you have any cautious expectation or insight on the direction of the UPC court for the permanent injunction requirement, if any? Thank you.
Yeah, maybe with regard to eBay requirement, this is part of the US law. As I understand, it is a part of the equity concept of injunctive relief. The system in all currently 17 contracting member states, they have a civil law background.
Okay.
So they simply don't have the system of equity. But what is existent and has to be respected is the principle of proportionality. This is part of the enforcement directive. In Article 3, paragraph 2, it is mentioned all means, and this includes injunctions, have to be proportionate. At the same time, it should also be mentioned, however, that of course this has to be argued by a party. If it is not argued, the court has no need to worry about proportionality, because in principle, when the court finds, yes, that the patent has been infringed, and the patent is an exclusive right, then I would think it is a natural consequence that a person who infringes an exclusive right has to be stopped continuing with the infringement. And only when this is disproportionate, then the court may either wait with stay the injunction for some time, or even don't issue an injunction at all. But these are exceptional cases. So there has to be an extra harm. Well, normally an injunction is a harm to a party. That's clear. But it is to stop an unlawful situation. So only if this then causes an extra harm which goes beyond the normal harm that is concerned, then I think the aspect of disproportionality comes into play. But we have to wait and see how this boils down in very precise situation. But one, of course, is a very classical situation that actually was a case from the UK. It concerned a heart valve. And there was only the product of the infringing product on the market, and then the argument, and this was the finding of the court in this case, was that a certain group of patients, if you stop issuing the hard valve, then surgeons were not able to implant a hard valve for a certain group of patients as it should be. And there was an alternative, but the surgeons were not trained to use the alternative, at least for some time. So the decision was, okay, you can continue selling the hard valves until the surgeons are able to implant the new one, which was a good alternative. And this kind of situation, of course, would fall under the requirement of proportionality. And then you, of course, can discuss this proportionality here.
Yes, great. No debate does not mean the, automatic injunction, right? Yeah, so you have proportionality and you're balancing interest, of course, public interest. Yeah, that's pretty persuasive. And another question? Maybe you can take one last question. Okay. Thank you. Go ahead, please.
My name is Ki-jung Kang. I'm from also BKL Korean law firm. Thank you for the great presentation. I want to ask about the protective letter issue. As you may know what I'm talking about.
마이크 다시 켜주시죠.
Hi, thank you. As you know, that protective letter system is originated from Germany, but this UPC decision is already different. It seems already different because the defendant submitted the protective letter, but the court said that it is not sufficient. So they issued the ex parte preliminary injunction, I think, yeah. What do you think about that? That might be the UPC law, will be the UPC standard about the protective letters?
Yeah, maybe if I explain protective letter a bit, what the concept is.
So you should explain what is protective letter.
Yes.
It's from German practice?
Yes.
Okay.
Yes.
Please.
Well, the idea is it addresses a situation that there is a request for a preliminary injunction in an ex parte proceeding. And so you only hear the one party that is requesting the preliminary injunction. But of course, as a judge, you should always try to get also the other party heard. And one way of having the other party heard is the protective letter. So when the other party has the feeling, okay, the patent owner may go to court and ask for a preliminary injunction, we want to be prepared and we want to be heard. And for that purpose, you can, like a preemptive submission, you can file a protective letter with the court in the register, and there your line of argumentation is outlined. So you say, okay, you should not issue a preliminary injunction because I'm not infringing and the patent is not valid because of this prior art and so on. This is normally on the background of a discussion between the parties that has already been happened outside of the court. Okay, and then the request really comes for the preliminary injunction, and the judges are, the registry is supposed to do so. They check, is there a protective letter, and they say, okay, yes, there is a protective letter. Then it is forwarded to the judge, and the judge reads the request for a preliminary injunction, and of course also reads the protective letter, and then forms the view on the case. And now also this way, having also heard the other party. And then the judge has to answer a few questions, I guess. The one is, well, do I still want to decide on what I read in the protective letter ex parte? That may be the first one. You can see, okay, the arguments, I don't know exactly about this, but at least I want to now to have a hearing, or at least hear the other party again.
Okay, all right.
So that could be one reason to have this protective letter. Or the judge says, okay, the arguments are so good, I deny the preliminary injunction. Or third possibility, well, they are not convincing at all. They brought the arguments, but they are not convincing at all. I issue the ex parte preliminary injunction. So that can be these are the three ways how to handle with the situation.
Yeah, is it officially adopted in UPC? Or?
Yes, it is.
Oh, okay.
Yes, it is. This is particularly relevant in cases where it's really very urgent cases. For example, you have a trade fair. It is the trade fair duration of the trade fair is 4 days. On day 1, they discover the alleged infringement. On day 2, they file the request for preliminary injunction. Then it gets to the court, and they cannot get in contact with the other parties, and it's very urgent because all the deals are made on on the trade fair. For this situation, this would be a typical situation where protective letter would make sense.
Most of cases is recommendable, but when you have bad feelings when you visit. All right. Okay, so I said last question, but we have 1 minute. If you have one more question, I'll take that. All right. Okay. Thank you.
My name is Doksun Chang, a lawyer at Kim & Chang here in Seoul, Korea. My question relates to how to enforce or execute the remedies or judgment granted by the UPC in an infringement action. I agree that the UPC is very effective in that the remedies will be given effect in 17 countries out of 27 EU member countries. But I understand that each country has different systems in terms of how to enforce or secure the compliance of the court's order by the losing defendant. So, for example, if the losing defendant is located in France, I'm wondering whether the UPC has the harmonized enforcement system as well, or the enforcement would be subject to the local law or procedures for the enforcement of the civil judgment.
Thank you. So it depends a bit on what you're going to enforce. If it is an injunction, then the way how to enforce it is that when you don't respect the injunction, then then the other party can come back to the court, and they come back to the UPC and ask for penalty payments because so this is decided by the UPC, and then only when if they were ordered to pay penalty payments, and then they are not going to pay, then of course you have to go to the national system and enforce this request for payment. A different situation is, for example, when we speak about seizure, because seizure is not about payment. It is really about enforcing physically an order of the court. And when we talk about seizure, then my recommendation, well, the court, it depends a bit on what the request of the lawyer, of the representative is. So the representative should know under which conditions seizure is enforced in France, in your example. And then should draft the request respectively, and then convince the court, okay, it is the way how it's done in France, and then the court will follow, and then they can enforce it in France as a judgment of a French court, because, as I mentioned already, the UPC is also a French court. It's a German court, a French court, a Dutch court. So this principle applies.
Okay, thank you very much. Thank you for all your insightful questions. The clock stops means we passed the time. And I'd like to again express my sincere gratitude, Dr. Grabinski, to sharing your insight and your perspective with us today. Your presence really make this session exceptional, and I firmly believe that the UPC will be the model court for all IP courts all over the world. Thank you very much.
Thank you. I'm sure everyone in this place got some insights and deeper knowledge about Unified Patent Court through this session. Let's give a big round of applause again. Thank you so much. We'll now take a break, which is always a good thing, and we'll begin the third session at 3:20 p.m. Please return to your seats before then. Thank you.